All right.
This court is resumed. Please be seated. Good afternoon, Justice Hennessy. When we left off, I was explaining how there were what I've called 3 wrongs that occurred after the decision of the Judicial Committee of the Privy Council. We talked about one being the 10th award, of which the arbitrators had no choice but to determine that it was a Section 111 situation. The second being that the capitalization of the future annuities, in capitalizing those, that the government's wrongly proceeded on a false understanding that the only obligation, mandatory obligation, was $4. And the third topic that I want to get to is the so-called release that Ontario relies on to suggest that following the decision of the JCPC, the Dominion released Ontario and Quebec from any further claims for amounts paid to increase the annuities. And that the release by Canada of Ontario and Quebec absolved Ontario and Quebec of all liability for future annuity increases. In fact, it only absolved them of future liability to the Dominion, not to the First Nations, and only in respect of annuities up to $4 per person. So I want to look at the so-called release, which is expressed in the orders in council that we had been referring to. No, the order in council expresses the negotiated agreement and was clear in making it in referring to the said increased annuities. So the first thing I want to look at is that order in council, which is at tab 14.
Of the compendium.
Of the compendium. So we were looking at this before the break. The page I'd like to look at is the last page of Canada's order in council.
The last page of the tab.
No, this tab has the 3 orders in council, Canada, Ontario, and Quebec. Here, in this respect, all the orders in council mirror one another, but let's look at the Canada's to begin with, because that's the document we were looking at earlier.
And it's the first one.
It's the first one. It's the one that sort of, the way that it's been photocopied is gray around the outside.
And the last page is
Is the one that's signed on the bottom.
John McGee or something.
I'm sorry?
John McGee.
Yes, it looks like that. I can't be certain, but it looks like that. We're on the right page. So at the beginning of that page under item 2, we started to deal with this when it speaks about the said capitalized sum of $205,000 and goes on to say, to be taken, that capitalized sum of $205,000 charged to the said Province of Canada account is to be taken to extinguish forever thereafter the annual charge of $8,200, which we discussed was calculated with reference to $4 per person, for and in respect of the annual claims of the Dominion on behalf of the said Indians for increased annuities under the said treaties, and that the Province of Ontario and Quebec, as representing the late Province of Canada, be and from after the 31st day of September 1892, relieved from all liability and further payment in respect of the said increased annuities, which may be payable under the treaties. So here the order in council is mirroring the language that has been used throughout, where there's reference to the said increased annuities, and it is clear in my submission that said increased annuities are those up to $4 per person. In that very same paragraph where it's mentioned, there's reference specifically to extinguishing the annual charge of $8,200, which is clearly calculated on the basis of $4. And this same language specifying the said increased annuities is adopted by Ontario. We see the very next page over is the province of Ontario's parallel order in council. It goes on to say in the last paragraph, oh, sorry, the last paragraph on the second page and under item 2, it's the same language, that the capitalized sum be taken to extinguish forever thereafter the annual charge of $8,200 for and in respect of the claim for increased annuities. And that Ontario and Quebec be from and after December 31st, 1892, relieved from all liability and further payment in respect of the said increased annuities, which may be payable. And finally, the same is repeated in Quebec's parallel order in council. Similarly, if you turn the page over and then turn to the second page, the paragraph at the bottom of the second page of Quebec's order in council mirrors that same language and specifically uses the term the said increased annuities. So then turning to tab 15. This is conveniently award 15 of the arbitrators. And we've characterized this in our written submissions as an imprecise summary of the agreement that was memorialized in the orders in council. This award 15 actually appended the orders in council, which were clear in stipulating that Canada released Ontario and Quebec only for the said increased annuities, which were those up to $4. So my first point here is, when you look at this award 15 at tab 15, you'll see that it's made clear in the preamble at the bottom of page 2 and whereas the said parties giving effect to such awards, these is awards of the arbitrators, including that 10th award the arbitrators were obliged to make. Whereas the said parties giving effect to such awards by mutual agreement and arrangement have in effect, as will appear by reference to the orders or minutes of council, of which copies are attached, consented and agreed as follows. And so here, this is just summarizing the agreement made between the governments. And the next couple of paragraphs summarize that agreement. And then on page, what's marked at the top is page 4 of award 15. First of all, in reflecting the agreement of the parties and summarizing that agreement, the arbitrators say at the bottom of page 3, with respect to the said treaties, that there be entered and charged in the province of Canada account, et cetera, over the page, the sum of $205,000 in extinguishment forever thereafter of any claims by the Dominion of Canada on behalf of the said Indians for increased annuities under the said treaties. And this is where we see what I might characterize it as some mischief, because the language has changed from the said annuities to just increased annuities. And I do concede that this imports some ambiguity. The arbitrators go on to say, and whereas it is desirable and expedient to give effect by our award to such consent and agreement of the said parties And then the arbitrators go on to effectively repeat the agreement that they have set out previously, and they repeat it in the form of an order, which they have specified they are granting on the consent of the parties. And because it is desirable and expedient to give effect to it, to give effect by our award to the consent and agreement. So you can see that this order, this award, the intention of it is really to tie a bow and tie a bow over the arbitration proceeding, put into effect the agreement that's being reached between the parties. It's intended, fully intended, simply to summarize the agreement that is properly reflected in the orders in council. The orders in council clearly refer to the said annuities and make that absolutely clear. This ambiguity in the award 15 does not create a new agreement. And we note in our written submissions, it's not the only ambiguity in award 15. I note, for example, that in summarizing the figures that go toward the calculation of the arrears due, the arbitrators seem to list twice amounts for 1892, which is a bit confusing. But when you go back and look at the actual order in council, you'll see that it's really clearly specified that that one of those figures in respect of 1892 is actually in respect of 1873. So that's just another example of the fact that this is an imprecise summary.
Imprecise or sloppy?
Sloppy, maybe.
I mean, imprecise suggests that the intention isn't precisely captured. I don't mean sloppy to sound so harsh, but an absence of proofreading.
Well, and I'll tell you.
Is that what you're saying? Or do you, by imprecise, do you mean they weren't really focused in, they weren't lasered in on what they were doing?
They weren't lasered in on what they were doing because they knew this was on consent. Their award really doesn't have, and I'm going to get to this, doesn't really have, I submit, legal authority. Because, as I will explain, they were actually acting outside of their jurisdiction on this point. They were simply making the award because they were asked to. They were asked to tie this up with a bow.
Arbitrators were.
Yeah, yeah. The arbitrators were outside of their jurisdiction at this point because their jurisdiction was only to bring accounts up to the end of December 31st, 1892. And here they're dealing with a matter about the future annuities, which really wasn't within their jurisdiction. They're issuing this award because they were asked to give effect to the orders in council. So I've used the word imprecise. It was not intended to be legally binding. It didn't need to be legally binding because the orders in council were. And I should just mention, the way that this award is structured, as I said, first it sets out the agreement between the parties, and we have the first reference to the extinguishment forever for increased annuities. And then that phrase is repeated when the arbitrators actually give their so-called award. And you see that on the very last page of the award 15, at the last page of the compendium, tab 15, where they repeat that language, in extinguishment forever thereafter of any claim by the Dominion on behalf of the said Indians for increased annuities. So I'd like to turn back to tab 13 of the compendium and remind the court, when I made my point that the arbitrators didn't really have jurisdiction. In fact, they didn't have jurisdiction to make this award. They basically did it because they were asked to, and it was expedient for them to give effect to the orders in council. And this was understood between the parties, and we can see that in the correspondence, specifically between Messrs. Hogg and Irving. And our written submissions refer to numerous letters between Hogg and Irving, which show that they both understood that the arbitrators were being asked to make a decision on to memorialize this decision on capitalization, which was completely outside of the actual arbitration. And I've only included in the compendium one such letter, but others are referred to in our submissions. So the letter that I'm looking at here at tab 15 is dated May the 25th.
Well, why do you think if they didn't need it, why do you think they asked? I mean, we often ask this in the court. Why are you asking me this? I said, well, you know, they just want to make it more formal or consequences, perhaps.
To tidy it up, it is the way that I view it. Let's see how it's expressed in the language of the letter here. This is a letter from Hogg to Irving. We can see that it's at the second page, and I just included one of them because this is a simple, brief one, but the same idea is repeated throughout. You can see it's written by Hogg, and it's to Irving, which you can see at the bottom left of the letter.
Tab 15, did you?
It's actually tab 13.
Thank you.
Oh, yeah, you know, I remember being told this was one error that the printer had, and I think the pages are reversed. You've got the second page before the first page. My copy turned out right, but
Not mine.
not yours. I wasn't thinking you would want to deal with this giant Surlocks or spiral binding. So here we have Hogg writing to Irving, and he says, in the second paragraph, the questions which you raise by your letter do not at present appeal to me as difficulties insofar as the capitalization of the increased annuities is concerned. We must first of all remember that the question immediately under consideration is the capitalization of the annuities, which are not affected in any way by the reference to arbitration or the awards which have been made. The reference, as you know, was to the effect that the accounts should be brought down to the 31st December, 1892. And in the making up of those accounts, interest was to be allowed, etc. So this is only one letter. The others are referred to in our written submissions, which show the parties' understanding that this is a question outside of the reference to the arbitrators. And nevertheless, for whatever reason, the parties felt that it would be expedient to have this repeated and tidied up in an award. And the way, as I said, that we went over that the arbitrators in Award 15 characterized it, they said, the parties have consented and agreed. And whereas it is desirable and expedient to give effect by our award to such consent and agreement, it's actually outside of the jurisdiction of the arbitrators to do this. But really, the primary argument is what was intended was the said annuities. They've appended the actual order in council, and what they're giving effect to is the agreement that is reflected in the orders in council. Now, there's all kinds of reasons why this release is not the release that it purports to be. The first reason is it would only apply if one were to follow the section 111, 112 pathway, because only in that case would the Dominion have a claim against Ontario and Quebec. And so only in that case would there need to be a release by the Dominion of claims against Ontario and Quebec. So you see how first we have to be on the 111, 112 path. And of course, our first submission is that's not the right path. The right path is section 109, as was found by the three arbitrators, Justices Gwynne and King, right? So this release, you only need to look at it if you were to follow the path and that section 111 and 112 applied, which in our submission doesn't. Secondly, remember, this release, and this is a related point, it's only the Dominion releasing Ontario. It's not, there's no release by the First Nations of Ontario. This doesn't affect Ontario's direct liability to the First Nations. And finally, the point that I've made repeatedly, it only concerns annuities up to $4 per person, because that's what everyone understood at the time was the extent of the mandatory obligation. But if that's not sufficient to convince this court, I do want to note Award 16, which conveniently is at tab 16 of our compendium. And this award was issued the same day as Award 15. And it was an award which appended the account. This one is the account of Ontario. This is appended the account of, I guess it's the province of Canada here. And puts into place the monetary consequences here. And the very last page of that Award 16, before the appendix, says, and right now I'm looking at the paragraph above the 3 seals on the last page. This award is made without prejudice to any claim that the Dominion of Canada may at any time have against the provinces of Ontario and Quebec conjointly, in respect of any debt or liability of the late province of Canada not dealt with in the said statement of account, for which subsequent to the said 31st day of December, 1892, the Dominion may be found to be liable. So the said statement of account is appended. We see that. It's actually quite a lengthy statement, and I've only included in the compendium the part of it that refers specifically to the treaties here. And if you're looking for that, you'll see it's on the left-hand column, the second from the last block of text refers specifically to this capitalized amount. You see that?
Okay. Could somebody highlight it for me, please?
It says actually the Huron and Superior Indian Treaties annuities, and it's hard to read, but it's got specific dates noted there.
Got it, thank you.
And then arrears, and then capitalization, right?
Thank
So this statement of account includes this capitalization amount that we're talking about, and goes on to say that this award is made without prejudice to any claims that are not dealt with in that statement of account. And in my submission, claims for beyond $4 per person are not dealt with in the statement of account, because the 205,000 only dealt with up to $4. So anything beyond that is not dealt with in the statement of account. And furthermore, it is clearly a debt or liability if you were to follow the 111, 112 route, which is, you have to be down that route to get here in the first place. You have to find that this was a debt or liability of the province of Canada, right? Remember that in order to be down this route, you have to accept that even if these annuities, even if these revenues are realized after 1867, there's still a debt of the pre-existing province of the no longer existing province of Canada. But this release specifically deals with such debts that may arise after, subsequent to December 1892. So it contemplates, in fact, that there may be some trailing debts, which we didn't know back in 1867, but the Dominion is liable to them subsequent here to the 1892 date of the settlement. It has in mind that there may be further debts we haven't yet considered that aren't part of the statement of account by which the Dominion is said to be liable. And so in my submission, this deals exactly with this situation. Now, my friends, you may remember from the evidence, and I think in their written submissions, will suggest that the related correspondence indicates that when counsel for the Dominion, Mr. Hogg, raised this issue with the arbitrators and said, oh, and can you put in that award, it's without prejudice to future things we don't know about that aren't already in the statement of account. Can you put that in there? There's a suggestion that he had in mind the Ewell Bridge. But it doesn't matter what he had in mind because it doesn't say with respect to the Ewell Bridge. It says with respect to any claims, any debt or liability of the late province of Canada not dealt with in the said statement of account for which subsequent to its date the Dominion may be found liable. So in summary, the so-called release, there is no such release. The order in council makes it clear that it's only the said annuities up to $4 that's being released. Canada acknowledges that part. Up to $4 pre-Confederation is being released. And also in respect to the capitalization for the future, up to $4 is being released. But anything beyond $4 is not being released. Award 15 does not create a new release. It simply is an attempt to put into place the actual agreement between the parties, which is reflected in the orders in council. Furthermore, Award 15 must be read together with Award 16, which was made at the same time, which clearly carves out debts or liabilities not included in that statement of account, which would include increased annuities beyond the 8,200, which form the basis of that capitalization amount of 205,000.
So on the one hand, you say, don't read that without prejudice statement to be any, or you say, don't consider that the without prejudice statement is limited by the comments of council and correspondence.
Or in fact, it was in submissions, this Ewell Bridge reference, is that what you're referring to?
Yes. It was only, but wasn't it later then referred to in correspondence?
Quite frankly, I don't remember whether it was referred to in correspondence, but if it were, I would have the same argument that on its face, the award does not confine it to the Ewell Bridge. But again, primarily my argument, Justice Hennessy, is that we're not even down this path. We shouldn't be looking at the 111, 112 path for a number of reasons. It's not a proper interpretation of the treaty. The proper interpretation gives the First Nations an interest in the ceded lands, so we should be on the 109 path. And the problem with 111, 112 is, have in mind, it would only make sense if all subsequent resource revenues realized by the province of Ontario were said to be debts existing at the union. It's illogical. As I forget which one it was now, of the justices that I took you through in the Supreme Court said, I think it was Justice Gwynne, it makes no sense to say that these were debts existing at the union of the province of Canada, which ceased to exist. These are our debts, as the way we've characterized it in our submissions, is the debts are actually crystallizing after Confederation when resource revenues are actually realized. So that's another reason not to go down 111, 112. The first one being it doesn't acknowledge the First Nations' actual interest here in the proceeds. The second one, it's illogical to assume that these are all debts that were existing at the union when they don't actually crystallize or aren't realized. The liability to increase the annuities doesn't arise until net crown resource revenues are realized, which has to be post-Confederation. And the third reason that it's obviously the wrong path is it would make Quebec liable for almost half of the resource revenues for sharing almost half of the resource revenues that went to Ontario.
Well, doesn't Ontario make that submission?
I think we're all agreed that yes,
I don't know that this court should look to that if Ontario is liable at all, it's liable for some portion that same portion
yes,
between Ontario and Quebec.
that it would be liable for roughly 53% and Quebec is liable for the rest. Nobody's brought Quebec in. You can expect that it's not because there's, if one were to follow the 111, 112 route, it's not that there wouldn't be a legal right to recover against them. The Supreme Court found in upholding Award 10, yeah, Quebec's on the hook. Obviously, none of the parties here have brought Quebec in. And I think it's fair to say, because it would make no sense to do so. It just doesn't make sense that Quebec should be liable for this. And that's one of the reasons why the Section 111, 112 regime can't be the right regime here. Now, I'm almost done. There are only just a few points that I want to address about, there were just a few aspects of Professor Messamore's testimony that I wanted to emphasize and put in context, because these are issues that you might remember there was some back and forth in the evidence of Dr. Messamore and Ms. Jones. And I just wanted to put that in context, a couple of interesting points. So Professor Messamore noted what might be on its surface an apparent inconsistency between the way that the fixed annuities, the £500, were dealt with versus the way the increased annuities up to $4 were dealt with. And she noted that the fixed annuities up to £500 was dealt with as a debt of the province of Canada to be shared between Ontario and Quebec. But Dr. Messamore said that when the Dominion provincial arbitrators looked at it, they didn't follow what the 1870 arbitrators did. They didn't apportion it. This is a province of Canada debt, split it between Ontario and Quebec. Remember, the three arbitrators said, no, this is a 109 situation. And Dr. Messamore noted, well, there's an apparent inconsistency there. Why would the fixed annuity of £500 be treated as the 111, 112 route, but the increase is up to $4? Why should they be treated as 109? And there's two reasons, Justice Hennessy. The first one, Dr. Messamore noted, she explained, it was expedient at the time in 1870 that the arbitrators were splitting up the debts as between Ontario and Quebec. It was expedient to consider these Indian annuities as a debt of the province of Canada and split it with the rest of the other debts. Now, Quebec complained at the time, and it was Cassot representing Quebec as counsel who complained at the time and said, no. Ontario gets all the lands that were ceded. So Ontario should be responsible for these Robinson annuities. But Ontario made the argument, well, a couple of arguments. And one of them was, yeah, but there's a parallel debt in Lower Canada because the government had determined in Lower Canada where there weren't treaties, there wasn't a specific treaty here, but the government nevertheless decided, the government of the then province of Canada, let's do something similar in Lower Canada. They set aside lands for the Lower Canadian First Nations, and they set aside $4,000 to pay effectively as annuities to the Lower Canadian First Nations. And in fact, in some years, that was even topped up, we saw, to specifically match the $4,400 payable for the fixed annuities under the Robinson treaties. So this was an argument that Ontario made. Look, there's an offsetting balance. It's an offset. So let's just treat them all as part of the province of Canada debt. And I just wanted to put that in context for the court because you may remember having heard the evidence about that. And I think it will also respond to any suggestions by my friends that, look, there's an inconsistency in what the Dominion provincial arbitrators do. Yeah, there was an inconsistency, but there's a reason for it. One of the reasons is that there was an offsetting obligation at the time of the settlement of these debts in 1870. But the second reason that it's not inconsistent, really, in principle. When you take a look at the fixed annuities having been found to be a debt of the province of Canada under section 111, 112, and the augmentations to be under section 109, is as expressed by Justice Burbage, acting as arbitrator, who noted that the fixed annuities and the augmented annuities are different. One sum had to be paid absolutely. That was the fixed annuity, and was not connected with the land. The other, the augmentations, was connected with the land.
So the fixed were not connected to the land.
That's correct. But the augmented annuities, as the arbitrators understood them, and as this court has told us we need to understand them, is that the augmented annuities are connected with the land. So we've cited from arbitrator Burbage's passage here at paragraph 371 of our written submissions. Arbitrator Burbage noted that the fixed annuities, which were capitalized and shared between Ontario and Quebec, were fundamentally different in nature from the annuity increases for which the Dominion provincial arbitrators found Ontario solely responsible. The fixed annuities were specified in the treaties as $2,000 or £500. The annuity increases, on the other hand, were linked to the productivity of the land. And we've cited there what arbitrator Burbage had to say when he addressed this difference in questions he posed to Ontario's counsel during an oral hearing. And that's at page 124 of our written submissions. And I'll look in particular at the second part. If I won't read the whole quote, but I'll read the second part. It seems to me that one might be clearly of the opinion that the fixed sum of, in that case, £600, he's speaking of the Robinson-Huron Treaty, the right to receive that was not an interest or trust attaching to the land or in the land in any way, and yet be inclined to think that the covenant to pay monies in case the produce was in excess of the expenditure upon the land was one running with the land. So arbitrator Burbage provides an explanation that that Canada would adopt. These annuities can be viewed differently. The fixed annuities, it's not at all inconsistent for the Section 142 arbitrators to have found that the fixed annuities were a debt of the province of Canada existing at the Union. And yet, for the Dominion provincial arbitrators to find, and I would ask this court to find, that the augmented annuities were connected to the land and therefore are the sole responsibility of Ontario under Section 109. The other point I wanted to bring us back to in Dr. Messamore's testimony, we've already touched on. Dr. Messamore was clear in her opinion as a constitutional historian that the Dominion would not have agreed to assume unlimited liability for debts of the province of Canada because this would not be fair to the other provinces. And the Dominion went to pains to determine, to attempt to treat all of the provinces equally. This is a point which arbitrator Burbage noted as well. And I think we've already gone through that, you may recall. Finally, Justice Hennessy, in concluding my submissions on the topic of Crown allocation, I feel like I need to address, but not dwell on, the interest issue raised by Ontario, which we deal with in our written reply. Ontario claims that not only is it only responsible for roughly 53% of the increased annuities, but that its liability to Canada is only 5% simple interest on that 53% debt to the First Nations. And in response to that, as I said, we deal with this in detail in our written submissions, reply submissions, but I would say, of course, the first line of response is that section 111, 112 doesn't apply to any increases after 1867. Ontario's liability is direct to the First Nations. But even if section 111, 112 applied, section 112 specifies how interest should be charged, but it doesn't say the principal is not due. And it has nothing to say about whether interest should be simple or compound. My friends have pointed to an award that specified that simple interest was agreed to in a specific context, which does not apply to the context that we're dealing with here before the court. Those are my submissions on the Crown allocation issue. Barring any further questions from you, I pass the torch to my colleague, Ms. Crew, who we're going to switch back to compensation issues and start with principles, the legal principles of compensation before we get into dealing with net Crown resource revenues and economic rents.
All right, thank you. Just let me catch up for a moment, please.
Your Honor, while you're catching up, if I may, I discussed this with court staff.
I'm catching up. I'm not following you.
I just wanted to ask your the court's indulgence to be seated during my submissions.
You have it.
Thank you.
Okay. Did I see someone handing something up? Thank you. Good afternoon.
Good afternoon, Your Honor. What was just handed up to you was Canada's Compendium of Authorities. Ms. Zhang also just circulated that via email to all counsel and to the court. I'd suggest that we mark this as an exhibit, as I'll be referring to it throughout my submissions. If I'm keeping track, I believe that's exhibit KK.
Was yours marked as an exhibit, Ms. Evans? I think.
No, it wasn't. And I remember that my friends marked theirs. So we should mark, I think we're up to KK.
I think if we mark the compendium for Crown allocation as KK and the compendium that was just handed up to Your Honor as LL, perhaps that would work well.
I had a note about that 3 times.
3 times. The one note I'll make is
I just need a moment,
Yep.
please. LL. So yours is authorities, but on what topic again? LL?
I would say it's the authorities, with the exception of the authorities on Crown allocation, which were in the compendium Ms. Evans has been referring to. So it's just the case law and really on the issue of remedies, principles of compensation.
So KK will be Compendium of Canada on Crown allocation, and Exhibit LL will be Canada Compendium on Principles of Compensation and Remedies. Is that good?
I think that makes sense.
Thank you. Okay.
The one point I'd add to that is the electronic copy that was just circulated does have highlighting in it, the portions that I'll be quoting from this afternoon and that Ms. Zhang will be putting up on the screen. So the printed copy does not have the highlighting.
Oh, the one for the judge doesn't.
The one for the judge was prepared, I believe, on Wednesday last week.
Everybody under the bus. Okay. But
Happy to stand in the way of the bus.
I will just ask you to be patient with me while I do my highlight. Okay, go ahead.
Thank you, Your Honor. As Ms. Evans advised, I'll be making Canada's submissions regarding the legal principles we say should guide this court's assessment and be applied to the evidence in order to fashion a remedy. I anticipate that my submissions will be between an hour and an hour and a half. I think we could go through those before going to a break, unless Your Honor objects to that, and let me know if you think there's a good time for a break that I should stop at before, if we don't get all the way through.
We usually stop around 3:15. Is that right?
Okay. Around 3:15, I'll take a pause then.
Thank you.
So in terms of my plan for this afternoon, I know that Your Honor is very familiar with all of the parties' written submissions, so I don't plan on going through Canada's written submissions orally. Instead, I've structured my submissions around what we see as some of the key legal questions raised in this case and how the jurisprudence provides answers to those questions. Of course, in addition to any questions Your Honor may have, which I'm prepared and very happy to answer as well, in our view, there are 4 overarching legal questions. The first is, given the novel circumstances of this case, what is the legal basis for a remedy? We refer to this as the remedy framework question. The second is, what guidance does the jurisprudence provide regarding what the Crown would have been expected to do had it not breached its obligations? The third question is, what role, if any, should principles drawn from equity play in this court's analysis? And the fourth is, what level of certainty must the court have as to what the non-breach world would have looked like, and do any presumptions apply that affect this analysis? I believe this will speak to the question Your Honor had for Ms. Evans on Friday about what results in realistic outcomes means. In grounding the answers to these questions in the jurisprudence, I also intend to show where the plaintiff's submissions are inconsistent with the law. And together with Canada's written submissions, my intention is for my submissions this afternoon to provide the court with a clear sense of what the jurisprudence says and what it does not say. Provided that Your Honor doesn't have any preliminary questions, I can start with the first question, the remedy framework.
Could I just ask you one thing? Could you keep your eye on me and I'll sort of nod when I'm ready for the next one. Thank you. Go ahead.
Thank you. So for the remedy question, the remedy framework question rather, that's not a question courts are often asked to grapple with. The remedy framework is almost always well established. It's common law or it's equity. But we say that those frameworks don't apply readily in this case. And we say that the jurisprudence supports that position.
You say neither framework applies?
Principles from frameworks can be drawn where they are helpful. We can take wisdom where we find it. But because of the sui generis nature of treaties and of the honor of the crown, our position is that there's a sui generis remedy-based treaty-based remedy framework that applies in this case. And we say that the ultimate purpose of the remedy should be to fulfill the treaty promise, and in so doing, repair the loss caused by the Crown's failure to diligently implement the treaty, restore the treaty relationship and the Crown's honor, and advance reconciliation. Now, I know Your Honor asked my friend Mr. Schachter on Tuesday last week whether there was any case law that spoke directly to the proper remedy for breach of treaty. And he responded that there was not, and we agree with him on that point. This is new ground, and there isn't an express case on this point. But despite that, while this is a new question and this is a new framework, Canada submits that our position is consistent with the Supreme Court of Canada and the Court of Appeal's prior jurisprudence on remedies in the Aboriginal law context, on the honor of the Crown, and on the nature of treaties. So I'll turn now to that jurisprudence, and for your honor to a few statements that are particularly relevant. The statement by Justice Cromwell, writing for a unanimous Supreme Court in Kerr and Baranow, is a good starting point. And you can find that at paragraph 71 of that case, compendium tab 6. And for those following along on the electronic copy, it's page 64 of the PDF.
So if you give me the tab first, I'll usually be able to keep up with you. So
Okay.
tab 6,
Tab 6, paragraph 71.
and it is sidebarred.
It is. The sidebars come from our prior submissions, when they were hyperlinked.
Very good.
So the portion that I would like to direct your honor to is the statement that, and it's a little bit 4 lines down on the sidebar paragraph. The remedy that follows once liability is established should be the one that is most appropriate on the facts of the case, rather than one derived from history or over-categorization.
And this is a quote from a text, is it?
Yes, quoted affirmatively by Justice Cromwell. It's by J.D. Davies, duties of confidence and loyalty. And it's quoted affirmatively by Justice Cromwell for the unanimous court.
Thank you.
What we say is that the crucial facts of this case, that it's a case of the breach of the Crown's duty flowing from the honor of the Crown to diligently implement a treaty promise, should inform the remedy. In these sui generis circumstances, history and over-categorization are not well positioned to guide the court. Justice Karakatsanis' statement, and this is in Mikisew Cree, tab 9, paragraph 44, is the next point I'll draw your honor to, as I think it echoes the sentiment or the statement expressed by Justice Cromwell. And Ms. Zhang has that up on the screen and highlighted. And the point here that I'd like to draw your honor's attention to is the statement that the principles of reconciliation and not rigid formalism should drive the development of Aboriginal law. What we see here is an echo of the statement.
Is this Mikisew Cree?
This is Mikisew Cree. Mikisew Cree 2018. So now we have two statements from the Supreme Court that say formalism, overcategorization, appeals to history, not particularly helpful in some circumstances. The third case I'll draw your honor to on that point is Hodgkinson's and Sims. That's at compendium tab 5. Page 413 of that case. For those following along electronically, it's at page 57 of the PDF. And again, Ms. Zhang, thank you for highlighting that. It's up on the screen. So the statement here is that the precise legal or equitable duties the law will enforce in any given relationship are tailored to the legal and practical incidents of a particular relationship. These are three cases, and we say the through line in all of them is that courts are directed to be responsive in fashioning remedies and to resist the application of formalism or categories when they aren't appropriate. So with that underpinning principle, we get to the nature of the honor of the Crown and treaties. Because in our view, that particular sui generis nature is what makes overcategorization or formalism inappropriate in this case. There's a very significant volume of jurisprudence on the nature of treaty promises and obligations flowing from the honor of the crown. I don't purport to go through all of that, and I think it's quite well known. I think the summary by Justice Karakatsanis in Mikisew Cree is particularly clear and weaves this jurisprudence together well. I believe Mr. Schachter also directed your honor to these same passages during his submissions. And so I'll ask Ms. Zhang to pull the case up on the screen for reference and direct your honor to paragraphs 24 and 28 of Mikisew Cree at tab 9 of the compendium. I'll do everyone a favor. I won't read from that case again. Certainly not that section. I'll summarize. There are a few key points here as I see them. The first is that the honor of the crown is not a mere incantation. It's a core precept. It gives rise to different duties in different circumstances. It's a heavy obligation, and it's a constitutional principle. And then at paragraph 28, and again, I'll summarize here. What the court is doing is they're summarizing the nature of treaties and the interplay of treaties with the honor of the crown. At paragraph 28, the court holds that the honor of the crown governs treaty making and implementation. The honor of the crown requires that the crown act to accomplish the intended purposes of treaties, that treaties are sacred, and that it's always assumed that the crown intends to fulfill its promises.
You don't have to answer if you don't know the answer, but what do you think that means? Treaties are sacred.
I think one of the key things that it's telling us is that, and in particular, if you look where this comes from, it comes from Badger, where the court is talking about solemn promises and really distinguishing treaties from other kinds of agreements. The statement that treaties are sacred.
Kinds of agreement. Oh,
Agreements.
yes.
What we see is when the reference to treaties being sacred is invoked, it's often doing two things. It's emphasizing their import. And what it is also doing is emphasizing that they are different from other kinds of agreements. I don't know about you, I've not heard a contract be described as sacred. And when you see this reference to that level, to that standard, my view is that that's where the courts are going with that statement.
different and more important. That's what you say is flows from or comes from the sacred? I
Different
don't know the
in-
answer, and I don't have any expectation that you do, but
Certainly different. That's, I think, why they're described also as sui generis.
mhm.
Different in the sense that they are also of a constitutional nature because of Section 35. Whether they're more or less important than an ordinary commercial contract, I don't know that I'm positioned to say, but I can point your honor to the jurisprudence that I think emphasizes their importance, but perhaps not comparatively.
Yeah, I just wondered if it's something different than all the other things that are said. If
I think it is different.
all the other things that are said, all the other descriptors of treaties.
Whether sacredness is different than sui generis constitutional principle. I don't see them as different. I think it goes to a bundle of describing the nature of treaties.
Okay.
But I think what it emphasizes is why we say that, and I understand that I believe the group of 5 plaintiffs agree with Canada on this point, that because of this sui generis, sacred, important constitutional status of treaties, the remedy framework should be responsive to that. It's our position that if the honor of the crown is not a mere incantation, if treaties are sacred, if the honor of the crown requires that the crown make diligent efforts to implement solemn treaty promises, that's the other S word that's used, sacred and solemn.
Different, but both S words.
Different S words, yes. Not 4-letter words, I'll emphasize. But we say because of this nature of both treaties and duties flowing from the honor of the crown in respect of their implementation, it should be the case that meaningful remedies aimed at fulfilling the loss resulting from the breach of treaty promises and duties flowing from the honor of the crown, that truly responsive remedies should be available. And in our view, that position is consistent with Justices Lauer and Pardew's findings in the Stage 1 judgment. That's at tab 15 of the compendium, paragraph 257. And again, my thanks to Ms. Zhang for having it highlighted up on the screen. So the statement here is that while the duty of diligent implementation has received only recent and isolated application as a basis for remedies in the treaty context, it is not a novel addition to law and is recognized in many authorities. Where the duty is breached, a court may order remedies aimed at ensuring that the Crown fulfills its treaty promises. And you'll have seen in Canada's submission, we come back to this phrase, remedies aimed at ensuring the Crown fulfills its treaty promises.
Does that have a focus on the future?
I think it could, depending on the circumstances. I think what Justices Lauer and Pardue are saying in focusing on ensuring the Crown fulfills its treaty promises, it's creating a remedial flexibility to look at the nature of the treaty promise and obligations and be responsive to it. Now-
Because I ask you that if it's a focus on the future, first, because Canada has taken a pretty strong position that the future should not be defined in the remedies. And second, because it doesn't say, this sentence doesn't say the court may order remedies aimed at repairing the breach or compensating for the loss. So it's just on this particular reading that's question arises, it seems to me.
I think there are 2 points there. In respect of Canada's position about future implementation,
Yes.
we have said that declaratory relief is appropriate, and there is case law on the nature of declaratory relief when it is issued against a Crown actor, that it is perhaps more persuasive than against an individual. And Ms. Evans will be speaking to future implementation, so I'll leave that to her with respect to the particular appropriateness of any given declaration or specificity in that declaration. But on your question about the reading of the sentence itself, whether it talks about ordering remedies aimed at repairing the breach or compensating for loss, and in particular past loss, I think you could read that sentence narrowly, but I don't think that it should be read narrowly. And there are a few reasons for that. But I think what this comes down to is reading that sentence in context with the rest of the decision that the Court of Appeal has made. And being quite clear, I believe, in reading that case, that they're saying that remedies are available for past losses. And what they're directing here is that the treaty promise is central to that assessment. I think reading this as only future looking would perhaps not accord with the rest of the judgment. I think the better reading is that it speaks to remedial flexibility with the treaty and the nature of the treaty promise and the obligations flowing therefrom as the central point. I'm seeing that it's 3:16. I don't know if Your Honor would like to take the break now.
Alan, just good. 15. Thank you.
This court is stood down for 15 minutes. Court is resumed. Please be seated.
Go ahead.
Before we left for the break, we were discussing the paragraph 257 of the Court of Appeals judgment.
Yes.
I won't bring us back there. I'm just situating us. And that final sentence in particular, a court may order remedies aimed at ensuring that the Crown fulfills its treaty promise. And I take it Your Honor has my position that that can be either retrospective or prospective.
Yes.
So as Ms. Evans set out on Friday, Canada has admitted its breach and has taken the position that the court can and should order remedies aimed at ensuring that the Crown fulfills its treaty promises. And that is the sui generis treaty-based remedy framework we say should apply. That the framework flows from the treaty itself and the honor of the Crown. Before I move on, I did want to quickly address the Court of Appeals' recent decision in Chippewas of Nawash, unceded First Nation and Canada. I believe you received a printed copy of that decision from my friend, Mr. Bass. I won't be taking Your Honor to any paragraphs in that judgment. Mr. Bass made submissions regarding that case. He took you to what I believe are the relevant paragraphs, so I won't retread that ground. I will just say, however, that we don't agree that the Court of Appeal was, and I believe this is how my friend Mr. Bass phrased it, unequivocal on equitable compensation being available. In Canada's view, Chippewas of Nawash and the statements therein regarding equitable compensation and that it may be available as an appropriate remedy is obiter, and it was made in a highly distinguishable context. And moreover, it doesn't contradict a treaty-based approach, which for all the reasons set out before we went on the break and in Canada's written submissions, we say is appropriate. The court in Chippewas of Nawash did not order equitable compensation or a constructive trust, which really is what it was comparing. Equitable compensation was being discussed in the context of the requested remedy of a constructive trust. And the court is saying that's disproportionate in these circumstances.
Can I just ask you one thing? When you say the court did not order, do you say at the trial and then there was nothing more done at the Court of Appeal?
That's correct. So like this case, Chippewas of Nawash was a phased proceeding. The remedies phase has not yet had a decision issued in respect of it. I don't believe it has commenced.
It has not been heard.
Yeah. So that's why we say it's obiter. The court is turning its mind to what might be available in the future, but there hasn't been evidence led in respect of this, nor any findings on remedy.
But which court said that a constructive trust was disproportionate?
That was the Court of Appeal.
Thank you.
What I think the Court of Appeal's judgment in Chippewas of Nawash does speak to is that, again, the Court of Appeal is emphasizing that it anticipates that meaningful remedies should be available for breach of the duty of diligent implementation, even without a corresponding breach of fiduciary duty.
Is that anything different than they said in this case?
I think the message is the same I think they talk about equitable compensation as a possibility a little more expressly. But again, this is a decision they've yet to make. I expect, or a point they've yet to rule on, this remedy framework question. I expect if this case is appealed, that it would be this case that they would consider that issue in. So it's novel ground. The farthest they've got.
Excuse me, what I was asking was, the Court of Appeal has dealt with this case, Restall case.
Yep.
And the Red Rock White Sand case at the same level as they have dealt with the Chippewas case, both after stage one, before a remedy stage. And so I wondered if you were saying, or if you can comment on whether the Court of Appeal said something new in Chippewas than they have in the decision in this case,
I don't read it as being new.
or new or different.
I don't view it as being new or different. I think that what it speaks to is that the court is anticipating that this is an issue that's coming before them in the future.
Thank you.
So that represents my submissions on the first question, the remedy framework question. Barring any further questions on that point, I think the next question that flows therefrom is, if the court accepts that the task is to craft a remedy that fulfills the treaty promise, the next obvious question is, what is the treaty promise?
Is that the same as the question 2 you gave me earlier?
No, Your Honor, it's I think a sub-question of the remedies framework. So I apologize. I should have been
Okay.
clearer about that, but it flows to the next question, which is, what would the Crown be expected to do?
Okay.
Something of a bridge, I suppose. Ms. Evans went over what Canada says is the nature of the treaty promise and the Crown's duty of diligent implementation extensively on Friday. So I believe the court has our position on that point. To very briefly summarize, there's a treaty promise to increase the annuity from time to time if resource-based revenues permit. This is a treaty right, and it's both mandatory in nature and monetary in nature. There's also a duty on the Crown flowing from the duty of diligent implementation, we say, to periodically engage in a process in consultation with the First Nation treaty parties to determine the amount of net Crown resource revenues and to consult with those parties to determine what portion, if any, of the increased annuity is to be distributed to individuals. These are required elements of diligent treaty implementation.
Is there a duty to consult on the sharing formula?
So what we have in the amended judgment is that there's an obligation to periodically engage in a process in consultation with the First Nation treaty parties to determine the amount of NCRR. That's what we have in the amended judgment. In my submission, that's as far as it goes, that this matter has been determined and it's reflected in the amended judgment.
And what duty, if any, does the Crown have with respect to dealing with a sharing formula or practice or conduct?
I think it goes to the duty of diligent implementation from the Crown to pursue the purpose behind the treaty promise. But as we see from the Court of Appeal, there's discretion in that engagement point. And as Ms. Evans said on Friday, Canada agrees that the Crown's failure in both regards, both in respect of the mandatory obligation to increase annuities and the obligation to engage in that process, demands a remedy that fulfills the treaty promise, repairs the loss caused by the Crown's breach of its duty. And the way to do that is to put the First Nation treaty partners in the position they would have been in had the Crown fulfilled the treaty promise and its duties. And we say that that approach is consistent with the approach as a first step that the Supreme Court directed in Southwind. And that case is at Compendium tab 16, paragraph 93. So in that case, in the context of remedying a breach of fiduciary duty, the Supreme Court directed that the first step in assessing equitable compensation is to determine what the fiduciary would have been expected to do had it not breached its obligations. And we say, while this is not a fiduciary duty case, and we submit the court is not or should not be assessing what would be referred to as equitable compensation, as in flowing from the courts of equity, we submit that it's also a helpful starting point. That is, that the court should begin by determining what the Crown would have been expected to do had it not breached its obligations. This is referred to in Southwind as the non-breach world, a world where the Crown complied with its duties, both in respect of the treaty promise fulfillment and the duty to engage.
Thank you.
And that's really how we get to a compensatory remedy in this case. It's Canada's position that a compensatory remedy is appropriate and necessary to fulfill the specific financial nature of the treaty promise to increase the annuity from time to time if resource-based revenues permit the Crown to do so without incurring loss. And to make one point clear, that's not to say that a compensatory award is always what's required to fulfill a treaty promise. And in the same way, a declaration will not always be sufficient. Treaty promises are varied, and as are the duties flowing from the honor of the Crown. And so what's required to fulfill those obligations will also be varied.
So do you say, given what you just gave me a moment ago, do you say a compensatory award is not always required and possibly not always sufficient?
Yes, I would think that it would depend on the nature of the treaty promise. So for example, in this case, there is already declarations that have been made in the stage one judgment. So that's part of the remedy as well, that the declarations are performing a meaningful function and often will perform a meaningful function. But in this case, because what the Crown would have been expected to do is pay money to fulfill a treaty promise, monetary compensation is required.
So necessity and sufficiency are measured against the,
They're measured against the treaty obligation and what the Crown would have been expected to do in the non-breach world, which then brings us to loss.
I was just trying to shorten it. Do I have that right? Necessity and sufficiency are measured against loss?
I think the step where we look at what the Crown would have been expected to do is important. And it is necessary. Because that's how we measure what the non-breach world looked like.
Okay.
The other duty we have is engagement and consultation. Those kinds of duties are often vindicated by way of declarations, and declarations do provide meaningful redress in many cases. But in this case, Canada acknowledges that more is required. This is where we get to the necessity and sufficiency piece that Your Honor just raised. As Ms. Evans said, Canada accepts that its breach of this duty to engage, particularly, I think as Ms. Evans put it, to bring Ontario to the table if it could, that failure contributed to the delay in the payment of the increased annuities. And we recognize that delay is a monetary loss in a time value of money sense. And because of that, that's how we get to a monetary award on this portion of the obligation. It's two slightly different paths. Payment just as a matter of a mandatory obligation versus payment for delay in the form of time value and of money. But in both cases, you end up with a compensatory monetary remedy. And that's because of the very particular nature of the obligations in this case and what the Crown would have been required to do. And because they did not do what was required, the plaintiff suffered a loss.
Okay.
If we start with the proposition of what the Crown would have been expected to do, we have to be cognizant of the standard of expected conduct. In this regard, there is a very meaningful difference between what a fiduciary duty requires and what the duty of diligent implementation requires. And this brings me to what Your Honor was just asking about whether you can cut out and go straight to loss, or if it matters what the Crown was required to do. And Mr. Schachter, in his submission, said that in assessing compensation, you don't look at what Canada would have done or could have done. You look at the plaintiff's loss. Now, I agree with Mr. Schachter. You don't look at what Canada would have done or could have done in any world. You look at it in a non-breach world. That is a world where the Crown complied with its duties.
So is that a would have or a should have?
Well, because there's a presumption of compliance. A non-breach world operates on the presumption of compliance. So it's both a would have and a should have. I think that this point is emphasized well at paragraph 115 of Southwind. That's at compendium tab 16. Again, paragraph 15. I don't know if Ms. Zhang is able to put that up on the screen.
I have it,
Okay, then we'll continue with that.
but there may be others who should see it as well.
115. Well, Ms. Zhang is putting that up on the screen and it'll be there for reference in just a moment. And because Your Honor has it in front of you, the statement is that the value of the loss flows from the nature of the breach and the obligation that the fiduciary would have fulfilled. That's the bridge. That's the step. I think Your Honor was asking whether or not we could. Ms. Evans just commented to me what that should have fulfilled is what's used here. And again, as I say, should have and would have operate in the same case here, because what's being fulfilled is what the fiduciary, but in this case, it's not a fiduciary duty. It's what the Crown would have done in a non-breach world. So would have and should have are the same. But what would have and should have the Crown done in this case in a non-breach world? It's not the same as what a fiduciary duty would impose. And we say that the definition of what would have and should have happened in a non-breach world are defined in Manitoba Métis. That's at compendium tab 8 at paragraphs 80 and 82. Manitoba Métis. And again, because the court has been referred to this paragraph, these paragraphs a few times, I think, I won't read from it. And I'll just summarize the key points as we see them. And those are threefold. The first is that Crown servants must seek, and again, seek to perform the obligations in a way that goes to the purpose behind the promise. And that while implementation may be imperfect, a persistent pattern of errors and indifference that substantially frustrates the purpose of a solemn promise may amount to a betrayal of the Crown's duty to act in an honorable way in fulfilling its promise. What the court is saying here is that the Crown has to be honorable, but perfection is not the standard. The would have and should have. The non-breach world is not a perfect world. It's one where the Crown complies with its duties. Any remedy that assumes that in a non-breach world, the Crown would have met a fiduciary duty, for example, acted in the exclusive best interests of its First Nation treaty partners and forsaken other interests, isn't consistent with the law that says that the value of the loss flows from the nature of the breach based on what the Crown would have been expected to do in a non-breach world. So this brings me to the distinction between fiduciary duties and the duties at issue in this case. The plaintiffs, I would submit, have gone to quite an extent to emphasize that they're not claiming there's a fiduciary duty in this case. But respectfully, their position seems to be that there is no practical difference. That it doesn't matter whether or not it's a fiduciary duty in this case. The result is the same. The non-breach world is the same, or that the Crown could have acted up to that standard. Our position is that fiduciary duties and duties flowing from the honor of the Crown is a distinction with a difference. These concepts, these duties can't be used interchangeably. And we submit this court should not accept that the results can be the same results can be arrived at irrespective of whether a fiduciary duty exists or not. To this point, I'll refer to some of the jurisprudence from the Supreme Court on the distinction between the duties flowing from the honor of the Crown and fiduciary duties. The Supreme Court's decision in Haida is particularly helpful on this point. That's at Compendium tab 4, paragraph 54. I think that's going to be the last page of the tab.
I do see something above paragraph 55. Perhaps it's the entire paragraph 54, but it's not clear.
Okay. Well, the portion that I would direct your honor to is the statement that while the Crown's fiduciary obligation and its duty to consult and accommodate share roots in the principle that the Crown's honor is engaged in its relationship with Aboriginal peoples, the duty to consult is distinct from fiduciary duty that is owed in relation to a particular cognizable Aboriginal interest. The court goes on. As noted earlier, the court, that is the Supreme Court, cautioned in Wakeham against assuming that a general trust or fiduciary obligation governs all aspects of relations between the Crown and Aboriginal people. Furthermore, This court in Guerin and the Queen made it clear that the trust-like relationship between the Crown and Aboriginal peoples is not a true trust, noting that the law of trusts is a highly developed and specialized branch of law. Now, this is a discussion of the duty to consult, which is also a duty flowing from the honor of the Crown, as is the duty of diligent implementation. And so we say that this statement provides meaningful guidance in this context as well. And we think that that's particularly clear because, and I won't pull this up, at paragraph 239 of the stage 1 decision, Justice Lowers and Pardue cite this statement in HIDA and describe it as, quote, the more nuanced approach. And they say at paragraph 241 that, like the duty to consult, the duty of diligent implementation is distinct from fiduciary duties. What we see in the case law is that central to fiduciary duty is the obligation to act exclusively in the best interest of the beneficiary. In this way, it goes above and beyond the fiduciary relationship. In our view, this point is made very clearly.
It goes above and beyond the fiduciary relationship.
Yes, meaning that there's a distinction, the duty. So contrasting the existence of a fiduciary relationship and the existence of a fiduciary duty, one of the key indicia of that distinction is this obligation to act exclusively in the best interest of the beneficiary. And this point is made quite clearly in Manitoba Métis. So I might take your honor to that. Manitoba Métis is at compendium tab 8. And the relevant statement is at paragraph 61.
Thank you.
So the court says, in order to elevate the Crown's obligations to a fiduciary level, the power retained by the Crown must be coupled with an undertaking of loyalty to act in the beneficiary's best interest in the nature of a private law duty. In addition, the party asserting the duty must be able to point to a forsaking by the alleged fiduciary of the interests of all others in favor of those of the beneficiary in relation to the specific legal interests at stake. And again, this is started with the phrase, in order to elevate the Crown's obligations to a fiduciary level. So that's when this becomes an obligation. It's our position that where obligations arise, remedies and remedial principles follow. You enforce a duty, you enforce obligations. Now, this takes us to the statement by Justice Lowers and Pardue, and I won't bring this up because I believe we're all familiar with it, that fiduciary duty has no work to do in this case that cannot be done by the honor of the Crown alone. But we submit that read in context, that statement is not properly interpreted as meaning that there is no practical implication, or indeed legal implication or remedial implication, for the Court of Appeals finding that there was no fiduciary duty in this case. What it does mean is that a monetary award is also available. We say that there are two reasons for that conclusion regarding the proper interpretation of that sentence, or sentence, portion of a sentence, really. The first reason is that the statement by Justices Lowers and Perdue was explicitly made in response to this court's concern, which Justices Lowers and Perdue summarize at paragraph 255, that absent a finding of fiduciary duty, remedies wouldn't be available. That was the concern that they were responding to in making that statement. And in response to that concern, they say there's no work to do. And then they say that that's because where the duty is breached, the court may order remedies aimed at ensuring that the Crown fulfills its treaty promises. That's where the statement comes from. It's in that context. That's why fiduciary duties don't have work to do here, because a remedy can flow from the treaty in the honor of the Crown.
Well, isn't the debate whether a certain remedy, for instance, the remedy that's subject to a debate, as I understand it, is the remedies with respect to future implementation, specific declarations with respect to future implementation. And you,
In respect of the, sorry, a clarifying question, if I might, in respect of whether there's work to do here or just remedies available at large for prospective and retrospective remedies.
let me try again.
Sorry.
The debate here, as I understand it, is with respect to the remedies for future implementation, whether there should be a series of specific declarations, how often the Crown should engage, how much disclosure they make, when, those kinds of specific asks. And you say, we don't need fiduciary duty remedies, because all we need is a remedy to ensure, let me get back to that, that ensures fulfillment of the treaty. Well, isn't that what the plaintiffs say? That's all we're looking for. Fulfillment of the treaty. So it's not, I don't think, best I understand it, it's not a debate on how to frame that a remedy is needed or that declarations are needed with respect to one of the breaches, but the narrower question is how specific those declarations should be. And I'm not, I need your help. There's no doubt about it. But I am not sure I am helped by the answer that a remedy does not have to be the same remedy as it would be for breach of fiduciary duty.
So I think there's a few
I'm not
points.
seeing where you are contrasting with what has been asked.
There are a few areas we're contrasting with what has been asked. There are 2 points here. The first is that in our understanding, the plaintiffs are saying that the nature of the fiduciary relationship does impact the award for the past, the retrospective fulfillment of the treaty promise. there's a few ways, as we understand it, that enters into their discussion and their submissions regarding the past. A lot of this comes back to the idea of presumptions, whether it's the presumption of most favorable use, and that's application to, in particular, bring forward and the 60-40 approach. But also, the concept was weaved through my friend's submissions regarding resource rents, about the size of the pie and what the Crown acting at a certain level would have done. Well, maybe it would have, chosen not to capture more rents, but it would have graciously said, but he doesn't use this word, but graciously said, we haven't captured this rents, but we'll provide it to you. They're calling on this idea that there's an elevated duty that we say doesn't have a practical distinction with a fiduciary duty. We say the logical, what's not being said in the argument is that to get to the point they want, you have to have a Crown who's acting in the exclusive best interests of the First Nation treaty parties.
Or the best and highest.
Best and highest interests of the First Nation treaty parties. Now, my friends may say that's not what they're saying, and clarification on that point might be helpful, because I will say it's not particularly clear to me how they're saying fiduciary relationship, what lifting that is doing, but it's certainly woven through their argument, and the end result they reach is of the same practical effect as a fiduciary duty. It's a non-breach world where the Crown is acting in the same way that a Crown imposed with a fiduciary duty would. So that goes to the past fulfillment of the treaty promise. Your Honor also asked about the future. I have to say, I'm not as well positioned as Ms. Evans is to speak about implementation and specifically what those declarations look like, can or should look like. But what I will say in respect of the law is that the declarations shouldn't impose on the Crown a fiduciary duty in practice. They shouldn't do indirectly what they can't do directly. Because if there's a practical difference, if there's a distinction between duties flowing from the honor of the Crown and fiduciary duties, that distinction, what the obligations entail, should be reflected as well in a forward-looking remedy. If the court goes down that path. And again, Ms. Evans has our submissions on what declaratory relief looks like, we say, in these circumstances. But from a legal perspective, our position is that there's a distinction at law, and that that distinction at law creates a distinction in practice. So I think it's helpful to also recall, when we're having this discussion, Justice Horrigan's unanimous reasons on the point of the distinction between fiduciary duty and duty flowing from the honor of the crown. And Justice Horgan is clear, and he's explicit that there are a number of remedial outcomes that would be available if there was a breach of fiduciary duty that would not be available in respect of a breach of the duty of diligent implementation. So to that point that he made that statement explicitly, that's at compendium tab 16, paragraph 602. The court says, a finding of a fiduciary duty.
I think I have the wrong tab.
Oh, my apologies. Thank you, Mr. Schachter. Tab 15.
Thanks.
I believe Southwind is tab 16. 602. So we have that. So paragraph 602, the statement is, a finding of a fiduciary duty greatly expands the scope of available remedies. The availability of those remedies must not drive the analysis of whether such duty is extant. And then at paragraph 606, court goes on to describe what that means in practice. Gives an example of what would be greatly expanded. Court says at paragraph 606, the beneficiaries in these cases could argue that they are entitled to the revenue generated and what could have been generated by the lands covered by the treaties. That's one implication, a practical and a legal implication of the distinction. It's why a decision was made on fiduciary duties. We say that that's particularly clear if we come back to the point in Southwind. What the court said in Southwind was the first step in assessing compensation. And that's that you look at what the Crown would have been expected to do if it had not breached its duties. And we say, if the court is not careful and deliberate about what those duties are and are not, if it intermingles or treats as interchangeable fiduciary duties, fiduciary relationship, and duties flowing from the honor of the Crown, as in our view, the plaintiff's arguments ask that it should do that. We say that that intermingling, that lack of clarity, would be inconsistent with the law. I do want to make one point very clear because we're contrasting these duties. By saying that fiduciary duties are different than duties arising from the honor of the Crown, we're certainly not saying that one is more or less important. Justice Lowers in Purdue said this explicitly at paragraph 254. I won't pull that up, it's quite short, but they say the honor of the Crown and fiduciary duties are not in competition. They're not in competition, but they are different. If the non-breach world is what reasonably and realistically would likely have happened if the Crown had complied with its duties, what those duties are has to matter. The final point I'll make on this fiduciary duties and breach flowing from the honor of the Crown point is that in considering what the non-breach world would have looked like, we submit the court should remain cognizant of the findings of the Court of Appeal and on stage one, and indeed, as your honor also found on stage one, regarding Crown discretion. And that is that while the Crown does not have unfettered discretion on whether or how to make increases to the annuities, it does maintain significant discretion in implementing the treaty. This should also be reflected in this court's assessment of what the Crown would have been expected to do in a non-breach world. That is, it would have exercised its discretion in a manner consistent with the court's findings on stage one. So this brings me to the third question that I set out in my outline, which is what role should principles drawn from equity have in this court's assessment? This section is quite short. I think, unless your honor would like, if we go to about 4:45, I expect I would be done with that question today. And then tomorrow we could finish with the fourth question, but I'm in your hands on that.
I'll check with the boss. You okay? Okay. Usually I would like you to focus on a 4:30 break. It's
Mhm.
predictable.
Yeah, well, it's 4:26. I'm happy to break now.
I think we should do that.
Okay.
As they say, this is a marathon, not a sprint. We'll break now till tomorrow at 10. Thank you. I won't be leaving. Thank you.
This court is adjourned until September 19th, 2023 at 10 a.m.